I'm Vince, the Invention Guy, here today to talk about how to patent, or the steps to patenting your idea. And let's start out right from the beginning here. The first step, obviously, is to look in the market and see if your idea exists. If you've gotten this far, you've probably found that your idea doesn't exist in the market. However, if your idea doesn't exist in the market, that doesn't mean that it doesn't exist in the patent office. So the next step here is to do a patent search and find out if anybody else has patented your idea. You can do this for free online yourself through something called Google Patents. So just type in Google Patents, that'll bring you to the Google Patent search engine, and you can do your own search online. If you don't find it there, that's certainly a good sign, and from there you want to get in touch with a patent agent or a patent attorney to help you move ahead. Now, that patent attorney is very likely to do a more in-depth search that you'll have to pay for, and if that search doesn't find any patents similar to your idea, then certainly you can move on to filing a patent application. Now, at this juncture, many people ask, can I write my own patent? The answer to that is a resounding no. If you're thinking of licensing or commercializing your idea, if you try to write your own patent, it's simply not going to have any strength. I approach companies all the time. They have $400 and $500 an hour patent attorneys who are going to review the application, and if it's not well written, they're certainly not going to do a deal with you. So your patent attorney will then write something called a patent application, which, if it's a utility patent, is generally a 10 or 20 page document. And I think it's also important here that the patent search is not just for finding out if other people have patented your idea. Your patent attorney is going to use that search to see what other types of patents are out there, what the minefield of other patents is like, and also to see how these other applications have been written and see how they were successful. So your patent attorney is going to bounce off those other patents. So when you do your patent search, save any patents that are even remotely similar to your idea. Your patent attorney will draft up this fancy patent application and review it with you. Once you approve that application, the patent attorney will send that application into the patent office, which is in Virginia in the United States and is in Hull, Quebec here in Canada. Once they send that application in, you are automatically patent pending that day. It's sent in electronically these days. The patent office stamps it and sends you a filing receipt right away. Now, this is a very important date because the patent office is a first to file system. It's not a first to invent system, it's a first to file, which means whoever gets into the patent office first will be recognized as the inventor of that product. So you certainly want to get your application in the doors quickly, establish yourself as the inventor, and again, obtain patent pending status. Once you're patent pending, you're really free to make it or sell it or license it. Most of the licensing agreements that I've been involved in have been in the patent pending stage. So you don't have to sit around and wait for your patent to be granted, as it does take some time. In fact, the U.S. Patent Office is taking on average 18 months just to review an application. So it's taking anywhere from 2 to 3 years for a patent to get granted. So you don't have to wait around for it to get granted. Now, down the road, the patent office will review your application, and they generally will reject some aspect of your application. Now, your patent attorney is going to write your patent in very broad terms. And one of my patent attorneys says that he writes a patent application like a beach ball because he knows that the patent office will beat us down, and eventually our patent is going to look more like a softball. So your patent attorney will write a very broad application. The patent office is likely to reject aspects of that application. Your patent attorney can then respond to them and kind of negotiate with them, and it's in that back and forth process that you get your patent granted. And then once you're granted, obviously that opens other doors. There's some big companies that will only look at granted patents. most companies these days will look at patent pending, but there's a few out there that want to see a granted patent. So those are the basic steps. I'm Vince the Invention Guy. Thanks for listening. Go to my site, theinventionguy.com, and subscribe or like this channel if you enjoyed it. Thank you for listening.